Hello, welcome to today's immigration tidbit. All right, so first you need to understand the law regarding illegal reentry after a deportation order. So if he in fact was deported in 2014 or 15, which you say he was, and then he reentered, it's a little clearer how exactly he tried to reenter. But if he reentered illegally, then he would be subject to the permanent bar. Okay, that means that you being a U.S. citizen spouse will not be able to help him, and that he would get deported permanently, where he could actually apply for a waiver of that permanent bar after 10 years. So it's funny they say it's a permanent bar, but there's a waiver after 10 years to get rid of the permanent part of it. So I need to know in 2016 how he entered. I'm about 98% sure, without you saying exactly how, that he probably entered illegally without inspection. However, if he happens to be in the 2 to 3% that came in, for example, with a fake green card, with someone else's ID other than a U.S. citizen type ID, and he was admitted, or if he drove through and for whatever reason he was waived in, then he would not be subject to the permanent bar. The permanent bar talks about illegal reentry after a deportation. And if the entry was not illegal, then that bar doesn't kick in. Now, don't confuse, for example, if he used someone else's green card with illegal entry. He did enter legally with someone else's green card, except now he'd be inadmissible based on fraud and he would need a fraud waiver, but at least he wouldn't be subject to the 10-year bar. So that's the first thing I need to know. Next, I'd need to make sure in 2014/15 that on his first entry he was actually deported, expeditedly removed. Or did he withdraw his application for admission, and was he voluntarily returned? Do you remember if they took fingerprints on him, and if he received a paper saying he was deported under 235B of the Immigration and Nationality Act? In cases like this, I need to most likely do a FOIA, which is a Freedom of Information request, where it will pull all the information that immigration has on him. Now, of course, some of it may be redacted, and if too much is redacted, you can appeal the response to the FOIA request in order to hopefully get an order to actually produce what they have. But I would need to have that, then analyze it and see what it is that they have on him, what he said, what he did, if he signed what's called an I-213, where they list supposedly everything they said to him and everything he said to them. In order to know, I would need to see, because there would likely be an expedited removal order if one exists. There would be a proof of his withdrawal of admission if he did withdraw. So, I would need to do that before we could go forward. Now, there are other types of visas one can get even with this situation. So, for example, if he was a victim of crime inside the U.S. and he cooperated with the police and made the report, he would qualify for a U visa along with waivers of all this stuff: waiver of the permanent bar, waiver of the deportation, waiver of the illegal reentry. I mean, it's a great visa for that. And sometimes, even though, you are a U.S. citizen spouse and can't help him, that might, it'd be unfortunate that he'd have to be a victim of crime in order to do this, but that's one way. So, I would need to know some facts and circumstances in order to see, but there's a way, once I would get all that, that I would hopefully be able to determine how to help your husband.